Hey everybody, Joel Silverman here from Silverman Law Office, here to talk today about guardianships and conservatorships. There's really four main instances in life where we need a guardianship or conservatorship. The first is when a minor is going to receive a financial windfall. So that may be due to some sort of disability or some financial event that happens in life to a minor, and we need a guardianship so that that person that's assigned as guardian by the courts can handle that money on behalf of the minor child. The second time that we need a conservatorship or guardianship is when we have a disabled child that turns 18. Because the law says at 18 we become of majority age, and therefore since they can't take care of themselves fully, we may need a guardianship or conservatorship at that time. Now, both those instances, we can plan for them. They're pretty easy to deal with. These next two aren't so easy to plan on. The third time that we have a guardianship or conservatorship is when an adult hits a stage of mental or physical incapacity. Usually we don't know that that's happening a lot of times for the children, but that's where we need to step in and we need to get mom or dad or aunt or uncle, family member, that protection from the courts that allows somebody to step in and handle not only the welfare of their physical body, but the welfare of their financial being as well. And then the fourth area that we need a guardianship and conservatorship is when the person becomes a danger to themselves or to others. And that's usually in the case of a mental issue. And so that's where we step in and we go to the court to get someone appointed again as that guardian so that they can ensure that that person gets the help that they need and the right care that they need for the rest of their lives, and that somebody can help them make the decisions that are in their best interest. So guardianships and conservatorships are very important, as you can see, throughout life, but we oftentimes run into two main hurdles when it comes to getting a guardianship or conservatorship. The first being when it's an emergency. If it's an emergency, something that's unplanned, we have to do an emergency guardianship or conservatorship. Those are the key words, emergency guardianship or conservatorship, so that we can get that family member or friend the necessary care that they need. And the reason this is a problem is because we're having to go to the court very quickly, and courts can be very skeptical of that. So we've got a higher burden to prove that this emergency guardianship or conservatorship is needed for that person's well-being. The other hurdle that we oftentimes run into is the lack of planning on behalf of the individual. If we don't plan, and that plan is by having a proper healthcare power of attorney where we express in that document who we want to be our guardian and conservator, if we have that document, we can walk into the court and say, Your Honor, here's what we need. The court sees the document, says, great, that's the proof we need. We can give an order. It's very easy. Without having a proper healthcare power of attorney that reflects your guardianship and conservatorship wishes, it makes our lives and the lives of your children much more difficult in getting you the protection that you need. So if you have any further questions about guardianships and conservatorships, give our team here at Silverman Law Office a call. We're happy to help. We want to make sure that you, your family members are protected so that your well-being is in the best interest of the family, and even that for your children that may need it as well. So again, give us a call here at Silverman Law Office. We look forward to hearing from you.